Confidentiality. Overview of confidentiality. When determining legal and ethical issues surrounding patient information, start from the foundational assumption point that all information given by the patient is both confidential, meaning it cannot be disclosed to others, and privileged, meaning it cannot be used in court. Then determine whether exceptions to these exist. The legal and ethical basis for maintaining confidentiality is that a full and open exchange of information between patient and physician is central to the development of and maintenance of a therapeutic relationship. Privacy is a right of patients, which they may forego, while confidentiality is a duty of physicians, which they must respect bearing patient consent or requirements of the law. Patients have the right to the expectation that their personal information will receive proper protection from unauthorized access. See privacy of medical records. We'll see next. If confidentiality is inappropriately breached by a physician, that physician can be sanctioned by the hospital court or regulatory authority. Based on the ethical principle of autonomy, patients have the right to control their own health information. Confidentiality may be ethically and legally breached in certain circumstances, for example, child abuse. While physician-patient privilege exists, it's limited in comparison to solicitor-client privilege. During conversations with patients about confidentiality, physicians should avoid promising absolute confidentiality or privilege, as it cannot be guaranteed by law. Physicians should seek advice from their local health authority or the CMPA before disclosing HIV status of a patient to someone else. Many jurisdictions make mandatory not only the reporting of serious communicable diseases, for example HIV, but also the reporting of those who harbor the agent of the communicable disease. Physicians failing to abide by such regulations could be subject to professional or civil actions. Legal duty to maintain patient confidentiality is imposed by provincial health information legislation and precedent setting court cases in the common law. Important. Legal aspects of confidentiality. Advice should always be sought from provincial licensing authorities and/or legal counsel when in doubt. CMA Code of Ethics and Professionalism. Fulfill your duty of confidentiality to the patient by keeping identifiable patient information confidential, collecting, using, and disclosing only as much health information as necessary to benefit the patient, and sharing information only to benefit the patient and within the patient's circle of care. Exceptions include situations where the informed consent of the patient has been obtained for disclosure or as provided for by law. Statutory reporting obligations. Legislation has defined specific instances where public interest overrides the patient's right to confidentiality. Varies by province but may include 1. Suspected child abuse or neglect. Report to local child welfare authorities, for example, Children's Aid Society. 2. Fitness to drive a vehicle or fly an airplane. Report to Provincial Ministry of Transportation. See Geriatric Medicine next. Communicable diseases. Report to local public health authority. See Public Health and Preventive Medicine next. 4. Improper conduct of other physicians or health professionals. Report to college or regulatory body of the health professional. Sexual impropriety by physicians is required reporting in some provinces. 5. Vital statistics must be reported. Reporting varies by province. For example, in Ontario, births are required to be reported within 30 days to Office of Registrar General or local municipality. Their death certificates must be completed by a physician, then forwarded to municipal authorities. 6. Reporting to coroners. See physician responsibilities regarding death. Physicians who fail to report in these situations are subject to prosecution and penalty and may be liable if a third party has been harmed. Duty to protect and warn. The physician has a duty to protect the public from a known dangerous patient. This may involve taking appropriate clinical action, for example, involuntary detainment of violent patients for clinical assessment, informing the police and/or warning the potential victims if a patient expresses an intent to harm. Canadian courts have not expressly imposed a mandatory duty to report. However, the CMA Code of Ethics and some provincial territorial regulatory authorities may oblige physicians to report, mandatory reporting rather than permissive. Concerns of breaching confidentiality should not prevent the physician from exercising the duty to protect. However, the disclosed information should not exceed that required to protect others. Applies in a situation where 1. There is an imminent risk, 2. To an identifiable person or group, 3. Of serious bodily harm or death. Disclosure for legal proceedings. Disclosure of health records can be compelled by a court order, warrant, or subpoena. Privacy of medical records. Privacy of health information is protected by professional codes of ethics, provincial and federal legislation, the Canadian Charters of Rights and Freedoms, and the physician's fiduciary duty. The federal government created the PIPEDA in 2000, which established principles for the collection, use, and disclosure of information that is part of commercial activity, for example, physician practices, pharmacies, and private labs. PIPEDA has been superseded by provincial legislation in many provinces, such as the Ontario Personal Health Information Protection Act, FIPA, which applies more specifically to health information. Duties of physicians with regard to the privacy of health information. Inform patients of information handling practices through various means, for example, posting notices, brochures, and pamphlets, and/or through discussions with patients. Obtain the patient's expressed consent to disclose information to third parties. Under Ontario privacy legislation, the patient's expressed consent need to be obtained to share information between healthcare team members involved in the circle of care. However, the patient may withdraw consent for this sharing of information and may put parts of the chart in a lockbox. Physicians have a professional obligation to facilitate timely transmission of the patient's medical records to third parties, with the patient's consent, such as for insurance claims. Failure to do so has resulted in sanctions by regulatory bodies. While patients have a right to access to their medical records, physicians can charge a reasonable fee commensurate with the time and material used in providing copies access. Provide the patient with access to their entire medical record. Exceptions include instances where there is potential for serious harm to the patient or a third party. Provide secure storage of information and implement measures to limit access to patient records. Ensure proper destruction of information that is no longer necessary. Regarding taking pictures or videos of patients' findings or procedures, in addition to patient consent and privacy laws, trespassing laws apply in some provinces. CPSO published policy is designed to help Ontario physicians understand legal and professional obligations set out under the Regulated Health Professions Act 1991, the Medicine Act 1991, and the Personal Health Information Protection Act 2004. This includes regulations regarding express or implied consent, incapacity, lockboxes, disclosure under exceptional circumstances, mandatory reporting, ministry audits, subpoenas, court orders, and police, as well as electronic records and voice messaging communications. It is the physician's responsibility to ensure appropriate security provisions with respect to electronic records and communications. With the advent of digital records, there have been increasing issues with healthcare providers that are not part of a patient's circle of care, accessing medical records inappropriately, for example, out of curiosity or for profit. All staff should be aware that most EMRs log which healthcare providers view records and automatically flag files for further review in certain cases. For example, same surname, VIP patients, or audit of access to records. Now, the Blue Notes. Legal aspects of confidentiality. Advice should always be sought from provincial licensing authorities and/or legal counsel when in doubt. I think I already read this. Let's read again. CMA Code of Ethics and Professionalism. Fulfill your duty of confidentiality to the patient by keeping identifiable patient information confidential, collecting, using, and disclosing only as much health information as necessary to benefit the patient, and sharing information only to benefit the patient and within the patient's circle of care. Exceptions include situations where the informed consent of the patient has been obtained for disclosure or as provided for by law. Ontario's Medical Expert Panel on Duty to Warn. CMAJ 1998. There should be a duty to inform when a patient reveals that they intend to do serious harm to another person, and it's more likely than not that the threat will be carried out. Where a threat is directed at a person or group and there is a specific plan that is concrete and capable of commission, and the method for carrying it out is available to the threatener, the physician should immediately notify the police, and in appropriate circumstances, the potential victim. The report should include the threat, the situation, the physician's opinion, and the information upon which it's based. While Canadian courts have not expressly imposed a mandatory duty to warn on physicians to alert third parties of a danger posed by a patient, Canadian Supreme Court decisions have held that a physician is permitted to warn, permissive versus mandatory. CMA Code of Ethics and Professionalism. Protect the health information of your patients. Provide information reasonable in the circumstances to patients about the reasons for the collection, use, and disclosure of their health information. Be aware of your patients' rights with respect to the collection, use, disclosure, and access to their health information. Ensure that such information is recorded accurately. Reasons to breach confidentiality: child abuse, fitness to drive, communicable disease, coroner report, duty to inform warn. Lockboxes. The term lockboxes applies to situations where the patient has expressly restricted their physician from disclosing specific aspects of their health information to others, even those involved in the patient's circle of care. Note that the Personal Health Information Protection Act, FIPA, provisions denote that patients may not prevent physicians from disclosing personal health information permitted required by the law.